19A1411, Thanquerious Calhoun versus the state. Lucas Westby for appellant, Brian Atkinson for appellee.
May begin when ready, sir.
May it please the court. My name is Lucas Westby of the law firm of Nelson, Mullins, Riley, and Scarborough, and we are here today representing the appellant Thanquerious Calhoun. Calhoun was convicted and sentenced to life for felony murder after the Georgia State Patrol performed a high-speed pit maneuver on the Toyota Corolla that Calhoun was driving up I-85. At 111 miles an hour, the pit maneuver caused Calhoun's fleeing car to spin and roll off the road into a tree, killing Marion Shore, the woman in the passenger seat. It is undisputed in this case that the pit maneuver caused Shore's death. This is a direct appeal of Calhoun's motion for new trial, challenging his trial counsel's complete failure to conduct a reasonable investigation or to put on a viable defense. His lawyer's performance was objectively unreasonable under Strickland v. Washington. First, he didn't adequately prepare by investigating the facts of the case. Second, his failure to prepare caused him to miss the critical defense, intervening cause. More specifically, he never investigated or developed evidence to present to the jury to establish that the Georgia State Patrol's use of the pit maneuver and deadly force on Marion Shore was the intervening cause of her death.
Counsel, walk me through exactly how this theory of intervening cause would have worked, because it strikes me that when someone who is responding to or is the victim of a crime responds in a perhaps unreasonable, perhaps even surprising way, that does not traditionally cut off responsibility on the part of the criminal.
And I would challenge that, Your Honor, and say that if the act is unreasonable or abnormal in response, whether or not the initial action was a trigger, it does cut off liability for proximate cause in that situation.
I mean, we say, for instance, our law is that if that everybody knows drug deals are dangerous and sometimes guns come out at drug deals. So if two groups of people meet to conduct a drug transaction and one of the buyers pulls out a gun, one of the sellers pulls out a gun in response, and they all start shooting at each other, even if one of the buyer's party is killed in the gunfight, and the buyer who pulled out the gun is charged with felony murder, I've never heard of a situation where we let them say as a defense, well, the other side overreacted. They didn't have to shoot back.
Sure, and the question there is it a reasonably foreseeable event that at a drug deal there would be guns and it could turn violent?
But why wouldn't it be a reasonably foreseeable event that this kind of maneuver could happen under these circumstances?
And that's precisely what trial counsel did not put before the jury. The pit maneuver, and I'm not here to argue today that the pit maneuver was per se unreasonable, but the jury should have been given the information to make that determination, and the jury wasn't. And the evidence that we put forward in our brief, evidence such as Georgia State Patrol troopers are trained to understand that the patrol cars are instruments of...
Why is that relevant for a consideration of reasonable foreseeability? Because the ordinary, I mean, reasonable foreseeability usually is sort of just a reasonable man standard, right? It's a reasonable objective person. The reasonable objective person has no idea what law enforcement training practices are. So the fact that law enforcement is trained not to do a particular thing in certain circumstances, it seems to me really to be beside the point as to whether it's reasonably foreseeable.
Well, if the conclusion is that something that is objectively unreasonable can still be reasonably foreseeable, then that would be, I think, new law in this state. The law is objectively reasonable under the proximate cause standard and the intervening cause standard.
It strikes me that if you are running away from the police at 100 miles an hour plus, it is reasonably foreseeable somebody, either you or the police, or some other driver may intentionally or may in error cause a crash. That strikes me as reasonably foreseeable, almost as a matter of law.
And under certain circumstances, Your Honor, I would agree with you, but the facts matter. And in this case, there was a superseding intervening cause where the state patrolman who performed the pit maneuver, in what we would contend to a jury, performed a pit maneuver that was unreasonable under the circumstances.
Counsel, might a defense attorney determine that blaming the state trooper would not be in the interest of their client, given the jury panel that they struck, given the, I mean, in other words, they might have, after voir dire, they might have said, look, I don't think with these 12 in the box that blaming the trooper is going to have any chance. It may backfire, maybe even worse for my client. Is that a reasonable thing that an attorney could have decided?
A reasonable attorney can conclude that, but that's not the record we have before us in this case.
The question under Strickland then is, if a reasonable attorney could have pursued the path that the attorney pursued, then we don't have deficiency, right?
I agree that's the standard, but in this case, the reason that the path wasn't pursued is because he was not prepared to pursue it. Now, the trial lawyer in this case said he wanted to put on a causation defense, but what he did not do is arm himself with the evidence, the police, the Georgia State Patrol training materials, their policies, and that information in order to present that evidence to the jury so the jury could determine what was a reasonable thing under the circumstances in this case. Because he didn't arm himself with that evidence and because he didn't educate himself.
Is your contention that it is only the absence of that particular information that makes it unreasonable? Because, you know, I'm just not sure how that is relevant to what is a very common sort of reasonable person assessment of foreseeability.
And if I understand your question, is that evidence material to the reasonability
is your entire
determination?
argument that they didn't have the pit maneuver, the piece of paper that explains how pit maneuvers and when they can be done and all those kinds of things, that didn't go to the jury? Is that what you're saying was not reasonable?
That's one of a constellation of errors, but the fact is he didn't put on an intervening cause defense at all. An intervening cause is an affirmative defense.
Just so I understand the defense, you're saying the troopers essentially acted negligently, right, under their policy?
If this were a civil case, that would be the language that would be used, correct.
Okay, so had it not been a state trooper, had it been another car that sees this high-speed maneuver and negligently, overreacted and turned into your client's car, and your client's car, same thing, went off the road and crashed and killed a passenger, you're saying that would be an unexpected intervening cause, that when you're driving 100 miles an hour, other people may act negligently towards you on the highway?
I think it's a different circumstance when you're talking about another driver making a mistake or acting negligently.
Well, again, it's negligence. Your theory of intervening cause is based on negligence of a chasing cop. It seems even more likely you're going to expect negligence of chasing anybody.
And Your Honor, I agree that can happen, but those aren't the facts that we're dealing with in this case.
In my hypothetical, are you saying that would be an intervening cause? That you would have a claim that it was unexpected that another driver could act negligently?
I think under your hypothetical, you could raise a defense and it would be for the jury to decide whether it was.
It might be, but when we look to prejudice, would there be any possible likelihood that a jury would buy it?
I think that, I don't know, Your Honor. I don't know if that question's been
prejudice.
Well, that's how we assess prejudice based on what we think reasonable juries would do. So had you put on this evidence that these officers acted negligently and the state argued, so what? It is reasonable that when you drive 100 miles an hour that somebody around you is going to act negligently, and then the judge instructs that you are responsible for the reasonably foreseeable consequences, you think a jury would have said, oh, yeah, that was an entirely unexpected result?
So I think that someone on the jury could see the evidence that we proffered as new counsel and reach that conclusion.
Not could. in reasonable probability.
A reasonable probability that someone on the jury would see the weight of the evidence proffered by new counsel, evidence that was not proffered in the original case, and make that determination. Yes, Your Honor.
But all that evidence would amount to the trooper acted negligently, right?
All that evidence would amount to the trooper was an intervening cause in this
the
case.
Okay, because the trooper was negligent. There's no evidence of an intervening criminal cause or an intervening intentional cause. It's negligence, right?
That's correct. In this case, we are arguing that the pit maneuver, but it's a criminal case, so whether it's negligence or something else,
But
it's
the
still
intervening cause that you claim is
Correct.
negligence. Do you have a case that says the negligent act of a third party is an intervening cause sufficient to break the chain of causation?
when something rises to the level of intervening cause. It is when that action is unreasonably, not reasonably foreseeable, or have an abnormal
You can
response.
announce that test.
That's
There
right.
have been a million criminal cases in the United States and in Georgia, and tort cases in which we apply proximate cause. Do you have any in which it was a negligent act was deemed to be an an unexpected intervening cause?
Sitting here today, I can't think of one, but if I think of one, I would be happy to submit a supplemental brief if you would like.
If you found one, that'd be fine.
Because a lot of your argument is about they violated the policy. That all kind of sounds in they did something intentional, but I don't understand your argument to actually be there was an intentional, purposeful, crime or tort. It's just the troopers did something they shouldn't have done and were very negligent.
And if I may address that, the pit maneuver itself was done intentionally, and that is in the record. They made the determination. They testified at trial as to some of the factors that they weighed before they undertook the pit maneuver on that vehicle, and then they testified at the evidentiary hearing on the motion for new trial as to some of the factors they did not consider, some of the factors they should consider, for example, the risk to the occupants of the vehicle other than the driver. And so the pit maneuver in this case was an intentional act. It
Now, I
wasn't.
understand the actual physical act was intentional, but your premise is that it was done in a negligent way because at too high speed, right?
And the premise is that it was done in a way that was not reasonably foreseeable or abnormal. Correct. Ultimately, because Brown did not prepare himself to put forward a causation defense, and there's no case law in his file, no notes, he ended up bungling the issue of causation at trial and was not able to articulate a coherent legal causation defense at all. He was therefore left arguing that Calhoun was not the sole cause of the accident, a correct statement, but meaningless from a legal standpoint. And he couldn't explain to the jury that a reasonable, safe alternative in this case would be to discontinue and apprehend Calhoun later. And so, having failed to prepare, he raised a nonsensical defense, arguing to the jury that nobody could identify Calhoun beyond a reasonable doubt because everything and everybody had just been moving too fast. Now, the state argues that this was a strategic decision and must therefore be presumed to be sound trial strategy. But this defense was actually factually foreclosed by the evidence turned over to Brown pre-trial. And now, Brown acknowledged he received discovery from the state, and that discovery included the accident reconstruction report. The report shows that the young woman, seatbelted in the passenger seat, died as a result of the crash. The passenger in the back seat was trapped, and according to the accident reconstruction report, it had to be removed by the jaws of life. He was also wearing a seatbelt. The third person ejected from the car was the driver, and it was Calhoun that they found on the roadway 40 yards from the crash. None of that was controverted by Brown's presentation at trial, and nor could it have been. The identity defense was therefore unreasonable because it was not viable at trial.
Had the decedent not been wearing a seatbelt in violation of Georgia law and in a negligent way, could you argue that's an intervening cause?
If the decedent had not been wearing a seat, whether that would be a reasonable trial strategy before a jury, you could argue it. whether or not you would be a question of whether that'd be a reasonable argument to make before a jury. It is.
Have you read our recent Mondor case?
I have, and in the Mondor case, that related to a seatbelt, and the Mondor case, though, does instruct that if there is some factual basis,
Well, we held
slight evidence.
We held in Mondor that it's okay to say you can't put on seatbelt evidence because not wearing a seatbelt is not, in a criminal case, it doesn't matter whether your victim is negligent or not.
And as far as, and I understand, Your Honor, and as far as that goes to intervening cause, that goes to the foreseeability of the intervening cause. And in that case, whether someone would be wearing a seatbelt is a question of foreseeability, as opposed to, in this case, the question of whether the State Patrol would use deadly force on innocent passengers to stop.
Is that the right foreseeability question, counsel? I mean, is the question, would the State Patrol execute a pit maneuver, or is the question, is it foreseeable that you would come into contact with another vehicle in traffic while driving your car this way?
If I think the correct question is whether it's foreseeable that the State Patrol would use the pit maneuver, because that's what happened in this case. Mr. Calhoun did not come into contact with another driver on the roadway that day.
But wasn't he exposed to that risk? And therefore, wouldn't that be a foreseeable consequence that he would have a car crash?
And if he had had a car crash caused by another accident, that would be a different case. But yes, I would say that may be a foreseeable risk.
A controlled accident? I mean, it designed to be. I understand that it was not here, but isn't that what it's designed to be, as a controlled accident?
Yeah, yes, it is. The pit maneuver at 35 to 40 miles per hour is designed to be a controlled accident. At 111 miles per hour, as the record evidence that we put forward shows, there's no control. It's just the use of deadly force on the car full of people. And I'd like to reserve the remainder of my time for rebuttal, if I may.
May it please the court, Mr. Chief Justice, Your Honors. I am Brian Atkinson. I'm here today representing the state of Georgia in this matter. The issue for Your Honors to decide is whether or not Thanquerious Calhoun received constitutionally ineffective assistance of counsel during the trial of this case, after which he was convicted by a jury of felony murder predicated on the felony offense of fleeing and attempting to elude a police officer. Back on May the 14th of 2013, Mr. Calhoun was driving a motor vehicle on Interstate 85 headed northbound through Banks County. Also present inside that vehicle were a female in the front passenger seat, Ms. Marion Shore, and another gentleman in the back passenger seat, Mr. Raphael Morton. A Banks County Sheriff's deputy determined the vehicle being driven by Calhoun was speeding, attempted to perform a traffic stop on the vehicle. Instead of pulling over to the side of the highway for the traffic stop, Calhoun accelerated and led law enforcement on a 21-mile-long chase that hit speeds in excess of 120 miles per hour and crossed into Franklin County. During that chase, law enforcement officers with the Banks County Sheriff's Office, Franklin County Sheriff's Office, and the Georgia State Patrol realized that Calhoun posed a grave risk to other motorists on the roadway and decided they needed to stop his vehicle. The first method employed to stop the vehicle being driven by Thanquerious Calhoun was to set up a rolling roadblock and have officers get ahead of the chase and attempt to slow down the vehicle behind them by preventing it from passing them. Mr. Calhoun avoided that maneuver by driving through the median and along the shoulder of the road in the emergency lane to pass those law enforcement officers' vehicles. Officers also attempted to place stop strips on the highway near exit 169, which Calhoun also avoided by making an evasive maneuver. Acting within the policy of the Georgia State Patrol, Trooper O'Neill Sadler terminated the chase near mile marker 175 by performing the precision intercept technique maneuver, what's been called the pit maneuver, which brought the vehicle to a stop, but unfortunately caused the vehicle to wreck into the shoulder of the interstate, resulting in the death of Ms. Marion Shore. The thrust of appellant's ineffective assistance of counsel argument today involves trial counsel, Mr. Joe Brown, failing to convince the jury that Trooper Sadler and not the appellant was the real cause of Shore's death. When evaluating an ineffective assistance claim, the appellant must show two things. He must show that trial counsel's performance was deficient, and he must also show that because of that deficiency, there's a reasonable probability that the outcome of the proceeding would have been different. This court does not have to decide either of those prongs in any order. If it finds that even if trial counsel was deficient, there was no prejudice, it does not have to decide the issue of deficiency. However, in this case, appellant has not shown either prong. Has not shown that Mr. Brown was deficient, and he also hasn't shown that any deficiency alleged would have changed the outcome of this proceeding. I want to start by discussing the argument that Mr. Brown was ineffective in failing to pursue the intervening cause defense put forth by appellant today. This argument fails for a number of reasons. The first reason is that decisions regarding which particular defense to raise or trial strategy that's within the discretion of trial counsel. As long as the defense theory is reasonable based on the evidence, questioning the efficacy of the chosen decision in hindsight does not establish ineffective assistance of counsel.
Did trial counsel say he wanted to and tried to present a causation defense?
Yes. Trial counsel did present both identity and causation as a defense in this matter.
If that was one of the defenses, how is it not deficient to go find out what the rules were for what you were trying to show was an intervening cause?
I think trial counsel testified at the motion for new trial hearing that he did research into the pit maneuver and determined that he did not have any additional evidence to present on that.
What did he say the sum total of his research? Did he actually get the Georgia State Patrol policy at issue?
I don't recall, Your Honor.
How hard would it be to go get that?
It would not be hard. I believe it's publicly available.
Okay. So that not deficient, that's the defense I want to raise, that the trooper was deficient. I understand that it has to do with the policy on pit maneuvers, but I can't be bothered to Google.
I think the trial counsel at the motion for new trial hearing did testify that he did internet searches regarding the pit maneuver. So whether he found, I don't remember whether he testified that he found the policy or not, but he did say he Googled.
That was a reasonable thing. He did it reasonably. That was all reasonable. That's the kind of thing you would expect a competent lawyer to do.
Is to perform an internet search for his theory of defense? Yes, Your Honor.
And not be able to find a publicly available policy of the agency in question.
Would the peculiar policy of a particular agency be terribly relevant in assessing objective reasonableness and foreseeability?
I don't believe so, Your Honor. And because the issue before the jury during the trial of this case, which the trial court instructed the jury on, was whether the appellant's actions were a legal cause of the death of Marion Shore, which is the proximate cause standard set out by this court in Jackson v. State, which goes to the reasonable foreseeableness of whether the outcome was could be predicted by the conduct.
What is it that needed to be reasonably foreseeable? Is it the fact that there was an accident or the particular maneuver that caused the accident?
I would submit that it would need to be reasonable foreseeable. There could be a collision with another vehicle on the interstate. And as long as it's reasonably foreseeable that there could be a collision with another vehicle under the circumstances of this case, which involved Mr. Calhoun driving his vehicle so close to passenger vehicles as to push them off the side of the roadway and to drive through the median, that it's highly foreseeable that a collision with another vehicle would have occurred. And that's what did occur. The pit maneuver is a collision between the Georgia State Patrol vehicle and
if there was evidence that the officer intentionally tried to purposely wanted to cause a deadly collision. The officer radioed, "I'm about to kill him," and turned and ran into him. That would be reasonably foreseeable. That would also show itself as a collision between vehicles.
Yes, Your Honor, but I think the officer's intent would be relevant in that case. And in that case, he would have committed.
So it's not just the fact that there was a collision with another vehicle. It has to at least be like a negligent collision?
I think it could be a negligent collision, Your Honor.
Aren't most collisions on the roadway negligent?
Yes, Your Honor. But I think that even if trial counsel was deficient in failing to get the policy of the Georgia State Patrol, that there's no prejudice. So the appellant can't show that he was prejudiced by that. During the motion for new trial hearing, appellant put forth evidence by two experts, one of whom was the training officer for the Georgia State Patrol who taught other officers how and when to perform the pit maneuver. And that officer was presented as an expert and was asked a question by the state of, given the circumstances of this particular case, was it appropriate for Trooper Sadler to have performed the pit maneuver? And would that trooper have any qualms in performing the maneuver himself? And he testified that no.
Why does that matter?
He had no qualms in doing that.
Like, why, if the question is, was something reasonably foreseeable as an objective matter, why does some individual's subjective view, even if they know everything about that kind of policy or procedure, why does their view of that matter? Wouldn't it have been more relevant to bring in random people off the street to say, you know, yes, we think that could have been a reasonably foreseeable thing?
No, Your Honor. I think it's relevant as to what the policy of the Georgia State Patrol
Why does
was.
that matter?
Because the policy of the Georgia State Patrol would guide how the chase was
For
responded
reasonable
to.
foreseeability purposes, who is it, to whom does the fact of this accident need to be reasonably foreseeable?
To a reasonable person.
Right. Is a reasonable person aware of all of the policies and procedures of the State Patrol?
Not necessarily.
No. So why does a fact that is not known to the reasonable person make that person find it more or less likely to happen?
And Your Honor, I think that question goes towards the prejudice prong, that the appellant must show that the defense was prejudiced by trial counsel's failure to bring this policy to light to the jury, because...
Well, it also goes to performance, though, because usually it's not deficient performance for a defense counsel to not waste a lot of their limited time looking for evidence that will be absolutely irrelevant.
Yes, Your Honor. And I think that whether or not the trooper, whether his action was reasonable, foreseeable under the guise of an expert, could be even inadmissible during a criminal trial as irrelevant, because it would not be relevant to whether a reasonable person considered it foreseeable or not.
Have you argued that in your brief?
I don't believe I have, Your Honor. With regard to the intervening cause defense, there is one other case that I did fail to cite in my brief, and it's a case that I wanted to bring to this court's attention. It's Neal versus the state, 290 Georgia 563, a 2012 case from this court where a man was ultimately convicted of strangling his victim. During the emergency medical technician's response to the victim, the emergency medical technician severed the jugular of the victim. The testimony presented at the trial was that the EMT was not negligent, but this court said that even if the EMT was negligent, and the EMT was negligent in severing the jugular of the victim in that case, that would not constitute an intervening cause because it wasn't gross misconduct. So that it's not mere negligence of a third party that could constitute an intervening cause, but it must be gross misconduct of a third party that's so far outside of the realm of what could be foreseeable that would constitute a legally cognizable intervening cause defense, which we don't have in this case. I think that, like the court in Neal, and like the evidence in Neal, the evidence that was presented in this case would show that Trooper Sadler's action of performing the pit maneuver was not even negligent, that it was objectively reasonable under the circumstances. And I would cite, Your Honors, to those two federal cases cited in the state's brief, Scott versus Harris, the United States Supreme Court case, as well as Sharp, the 11th Circuit Court of Appeals case.
Yeah,
I recognize
I don't
those.
understand how that helps you. Those are qualified immunity cases.
Yes, Your Honor. I recognize those are civil cases on the issue of qualified immunity, so the court should look to what those courts were deciding, and they were deciding whether the officer's actions were objectively reasonable. And those courts both came to this
Objectively
conclusion.
reasonable under established precedent.
Yes.
Okay,
And based on what we expect
different test.
reasonable law enforcement to understand is reasonable, that's not necessarily the same thing as what we would expect just a normal, reasonable person reasonably to foresee, right?
Yes, Your Honor.
I mean, the violation of various policies and procedures can be unreasonable and defeat qualified immunity, but the average reasonable person wouldn't even know those things existed, right?
Right.
Okay.
Which, again, goes towards the appellant failing to show prejudice of the deficient performance, because that issue of whether the officer acted within the policy or not is not, would not be known to the ordinary reasonable person. I do want to point out that trial counsel did argue the issue of causation and based his argument on the charge of the court that was given to the jury in this case. The court charged regarding the legal relationship between the felony and the homicide, that in order for a felony to serve as the basis for the crime of felony murder, it must be proven beyond a reasonable doubt that the felony offense was either inherently dangerous or life-threatening under the circumstances in which it was committed, or the circumstances attendant to the commission of the felony create a foreseeable risk of death. And trial counsel did latch on to that last language of the trial court's charge of felony murder in his closing argument to the jury and made an argument based on it. Now, trial counsel argued to the jury that it was not reasonably foreseeable for the actions of appellant during the commission of the felony fleeing to have led to the death of Marion Shore, because Trooper Sadler's act of initiating the pit maneuver, which resulted in the collision, which resulted in Shore's death, was not reasonably foreseeable. So he put that argument before the jury for the jury to consider the full legal argument of foreseeability in this case, and the jury decided that issue adverse to appellant and found that it was reasonable foreseeable. And this court in Robinson versus the state talks about the proximate cause between an underlying felony and a homicide, and acknowledges that whether or not it's reasonable to foresee something is a question that's going to be left totally into the jury's decision based on all the evidence put before it during the trial. Appellant also argues that trial counsel was deficient in failing to hire an expert to testify regarding the pit maneuver. And I'd point out that that argument fails because there is no prejudice to the defendant in failing to hire an expert, because the two experts that testified at the motion for new trial hearing presented equivocal testimony between the two of them. The experts presented, one testified that given the circumstances, he would have performed the pit maneuver in the same manner as Trooper Sadler did in this case, and neither expert testified that the pit maneuver or decision to perform the pit maneuver were done contrary to either Georgia law or to the policy of the Georgia State Patrol. I also submit that appellant hasn't shown that failing to call the experts presented in the motion for new trial was even deficient. While Dr. Alpert, the expert most favorable to appellant, did say that in his opinion there were public policy concerns regarding what the policy of the Georgia State Patrol was as it related to pit maneuvers, that had no bearing on the issue before the jury when deciding this case, which was simply whether Thanquerious Calhoun was the proximate cause of the death of Marion Shore. Dr. Albert's testimony regarding public policy wasn't based on the law, but what was based on what he believed the law should be. So trial counsel cannot be deficient in failing to call an expert who is going to testify in the manner that Dr. Alpert testified at the motion for new trial hearing. And even if he did call that expert during the trial of this case, there's no reasonable probability that the result of the proceeding would have been any different. I also do want to touch on the state's supplemental brief filed and the argument raised there that trial counsel testified at the motion for new trial hearing that one of the reasons why he did not hire an expert was because of monetary or financial constraints. And there was no evidence presented that the appellant or anybody else was willing to spend money to hire that expert. The testimony was the opposite. But because trial counsel was retained in this case, there is nothing in Georgia law that would allow him to apply for or receive public funds to hire an expert. This court was actually presented with a similar question earlier this year in Duke versus the state, which both parties in this court acknowledged was a question of first impression because it involved, the first time, in that case involved pro bono counsel seeking public funds to hire an expert for the first time since the inaction of the Georgia Public Defender Standards Council legislation came into effect. And so trial counsel cannot be deficient in failing to forge a new area of law. The standard is what a reasonably competent attorney would have done given the state of the law at the time. And that issue was actually decided adverse to appellant since this in a Court of Appeals case, Bonner versus the state from June of this year. The case number is A19 A0168, the Fourth Division of the Court of Appeals. Considering a similar question of trial counsel failing to hire an expert and failing to obtain public funds to do so, said that the law was unsettled, that Georgia law provided no mechanism for retained counsel to do that. So trial counsel could not be deficient in failing to forge that new area of law. Before my time is up, I do want to point one more reason why this court could affirm the trial court's order denying the motion for new trial, and that is that this ineffective assistance of counsel claim was not raised at the first opportunity for it to be raised. There was a previous motion for new trial which the appellant was represented by the public defender for the Northern Judicial Circuit, who did not raise ineffective assistance of counsel at that motion for new trial.
Thank you, Mr. Atkinson. Mr. Weston.
There's a lot that I'd like to address from there, so I will try to move relatively quickly. But with regard to who is considering what is reasonable in this case, that is precisely the problem, is the jury was to consider what is objectively reasonable in this case, and Mr. Brown never armed them with the information, for example, about what deadly force is and what the police procedures say about deadly force. And so it is for the jury to determine what an objectively reasonable person would do under the circumstances.
You have to show that it would have made a difference.
That's right. And the prejudice issue, I'm going to just deficiency right now.
But either one of them can, I mean, you have to prove both. And so we can spend the whole day talking about the first prong, but if you don't have prejudice and you haven't shown that it's probable that the outcome would have been different, it doesn't matter.
Yes, Your Honor. And the prejudice in this case is that the jury never got to hear an affirmative defense.
That's a little circular.
Well, and because of that, the only crime that my client has been sentenced to life in prison for is felony murder. That affirmative defense went directly to that crime.
That still doesn't make it prejudicial. I mean, the reality is there is no good defense. I mean, identity wasn't a great defense. Causation's not a great defense. The trial counsel tried both of them. But why is it a good defense to bring in? I'm not even sure the policies are relevant. Why are the policies relevant to what a reasonable person would understand is reasonably foreseeable?
The policies are relevant because those are what guide the decision making of the patrolman making the pit maneuver.
That's not the question's whether the defendant it was reasonably foreseeable to a defendant that these things would happen, how would a defendant have any clue what particular police agency policy would come into play?
I mean, what it really sounds like is that you're arguing that the manual wasn't followed. But arguing whether the manual was followed or not is not the same inquiry that the presiding justice just put forward to you.
And so, as I understand, the question is, was it reasonably foreseeable to a driver that the police would perform a pit maneuver under the circumstances?
There would be, that somebody would collide with them negligently. If I try to elude police at 100 miles an hour, it's not a crazy thought that I'm going to have somebody run into me by mistake or negligently, not grossly and not criminally, which I understand you told me before you're not contending.
Well, and I want to maybe parse what I said a little bit more. The act of running into Mr. Calhoun in this case was an intentional act. The failure to apply the considerations that he is supposed to apply per his training and per the policies, that may be a negligent decision, but the act itself was intentional. This was not a driver who just turned into Mr. Calhoun. Going to trial counsel's preparation, we got the policies and we got the training materials and we got all of that through an open records request.
Thank you.
Thank you, Court.